This is Hillary Topper on Air, the Endurance Sports Podcast. This podcast will help you grow both personally and professionally. It's a lot about endurance sports, but it's not only about endurance sports. It's about lifestyle. It's about helping you achieve your goals, both personally and professionally. So just keep listening in. This is episode 511. And today on Hillary Topper on Air, we're going to talk about the essential Medicaid planning strategies for guardians. Guardians play a specific and critical role in navigating Medicaid eligibility, overcoming common challenges in court, and implementing effective planning strategies for incapacitated individuals. My guest today is Eric Einhart, and he's a partner at the Russo Law Group. Eric, welcome to the show. So, can you explain to us the role of a guardian in Medicaid planning for someone who is incapacitated and how it differs from traditional Medicaid planning?
Yeah, sure. Thank you so much for having me. So when you have someone who is in need of a guardian, typically they have a lack of capacity because that's what gets them to the position where they need a guardian. And that lack of capacity oftentimes will result in the need for long-term care services, and those services can be very expensive. So the guardian's job is to manage the personal needs of the individual, the incapacitated person, and also the property management of the individual. And if they're spending a ton of money on long-term care services, really it behooves them, and it is in the best interest for the incapacitated person to investigate other options for payment of those services, like Medicaid. And Medicaid is a means-based program, so you can't have more than a certain dollar amount and still qualify for it. So there are certain efforts that the guardian would need to put forth in order to become eligible or help the person become eligible. So the challenge or the distinction really is you need to go through a court system to have any those transfers or that plan established, versus if you had capacity yourself cognitively and you still needed assistance with long-term care, you could just do that yourself. Or if you have a power of attorney, that agent under the power of attorney can kind of make the maneuvers that are necessary to get you eligible for Medicaid without having to jump through the extra hoops of going through the court system.
You know, a lot of people ask me, they say, what's the difference between Medicaid and Medicare? Maybe you could kind of like just give us a quick overview before we go further with some of these in-depth questions.
Sure, absolutely. So that is a very common question, and it's confusing. They should have probably named it a little something different, so making it not so closely named, right? So Medicare is a health insurance essentially. If you've paid into the system and you're of a certain age, I think it's 65 years old, you may be entitled to Medicare, and that would cover doctor's visits, hospital stays, prescription medication, depending on what type of Medicare program you're on. Um, and that coverage does not usually extend to long-term care services. It can extend to long-term care services for very specific reasons, like for instance, a stay in a rehabilitation facility. Medicare will cover a certain period of time or a certain number of rehabilitation, but after that time is up, then you're on your own in terms of the cost of that care. And that's when Medicaid typically comes in. Medicaid is a means-based medical insurance, essentially, for specifically for long-term care services. So if you are in a position where you're over 65 and let's say this is a very common situation, you've fallen and you go to a hospital, you stay in the hospital for a number of days, and you need rehabilitation because of an injury based off of the fall, you'll go to the rehab facility, and Medicare will cover the first 20 days 100%. Then the next 80 days, they'll cover the cost of your services for rehabilitation with a copay that needs to be paid. It's like $200 at this point, a day per day. And then if you stay beyond that 100 days, or if you are no longer rehabilitating your care, you're not medically advancing, you've plateaued, then they're going to consider that personal care, and that essentially is long-term care services that Medicaid would cover up, pick up the tab from there. So Medicare does cover some long-term care services, but it's very limited, and it's it could stop at a moment's notice. So if you're no longer rehabbing, you're now getting long-term care services.
Wow. All right. So now someone falls and they go through this whole rigmarole, and now but they're incapacitated in some level. Maybe they're starting to get dementia, and the dementia's really overtaking them, and they need a guardian to
Mm.
help navigate this. Okay. So, could you talk a little bit about some of the challenges that a guardian would take when navigating these Medicaid eligibility rules, especially concerning the assets and income of this person with severe dementia?
Well, if they're appointed as the guardian, the first thing they should be mindful of are the specific authorities that they have. So the court could limit the authorities to certain things. And you want to make sure, as the guardian, you have the ability to, number one, first and foremost, access financial records and financial accounts, just to make sure you could ascertain the scope of their assets, to find out how much they have essentially and where it's coming from, and understand what the income sources are. And once you have an understanding what the person's assets are and their income, then you can kind of work from there in terms of determining what is considered a countable resource versus a non-countable resource from Medicaid eligibility perspective. So, for instance, if in New York right now, the accountable resource allowance is $31,175 for an individual. So, if you have more than that in countable resources, you're gonna have to either spend that down or transfer it out of your name to a exempt transferee, or suffer the consequences of a transfer penalty period. So, the guardian would need to figure out how much assets this person have. Of those assets, what are considered countable, which are going to count against you for eligibility for Medicaid, and what is non-countable. And that's where an elder law attorney who knows this stuff and lives and breathes in this kind of world it could help the guardian go through and navigate this process and understand. Well, that's not a countable resource. You don't want to collect that. You don't want to liquidate that. That could be a tax implication. So it is not something I would ever suggest for the guardian to go alone. Even if the guardian is an attorney, they may not be familiar with the ins and the outs of Medicaid eligibility, and I would really caution them against doing it themselves. It really should speak with an attorney who has experience in this area.
Yeah, I mean, I 100% agree with you because it's just so much that you have to deal with when you are a guardian. Now, does a guardian need to have a power of attorney for that person and also all their healthcare proxies? I mean, is that part of the role of a guardian?
That's a good question. So um, no. If the individual who's now incapacitated has a durable power of attorney and has an existing healthcare proxy, and those documents are properly executed, and they grant the level of authority that is necessary and appropriate, then there is no uh, typically there's not really a reason why you would have a guardian, except that there's some sort of power that the power of attorney didn't give, or the healthcare proxy didn't authorize. That's when you would commence a guardianship proceeding. But generally, so for instance, if I have a durable power of attorney, validly executed and giving robust authorities, and have a healthcare proxy and a HIPAA authorization, those documents, 95% of the time, obviate the need for a guardian. So if there is not those documents do not exist, that's when you have a guardian appointed, and the guardian's role is not to get those documents, it's to do the job of the power of attorney would have done otherwise.
Gotcha, gotcha. Okay. Now, back to the guardian, right? So, what are some of the key steps a guardian must follow to obtain court approval for Medicaid planning with within the guardianship proceeding, and how long does
Okay.
this process take?
Okay, so it can be pretty lengthy, the process, but anything to do with the court system, unless it's authorized for like an emergency hearing or something, and it can be pretty lengthy. The process, this is going to sound self-serving because I am an elder law attorney, but really should be the guardian should first meet with an elder law attorney to find out what the plan should be, and then from there, you know, carefully present it to the court. Um, so you're you cannot, even if you're the guardian and the court gives you the authority to manage the financial affairs of the individual, a lot of times the Medicaid planning involves transferring assets out of the person's name, which is kind of contrary to the role of a guardian. You're supposed to protect this money, not give it away. But there are strategic reasons why you would want to give it away in order to help them qualify for government benefits. And so you want to think through a number of things. Number one, what are the resources? What's countable versus not countable? Is the income sufficient to cover the long-term care costs where, that would make a Medicaid not necessary or economically not beneficial? What is the family dynamic like? Who of these family members would be considered an exempt transferee? What's the relationship like that? So the first thing you're going to want to do is get a full picture of the assets, the dynamic of the family of the individual, and the type of services that are needed. And then you're going to present an application to the court and say, here's the plan, here's why it works, and here's what we expect to happen if you approve it, Your Honor. And usually that'll require a hearing. And what I like to do is have a very lengthy and detailed memorandum of law and fact so that the judge and anybody who comes into this reads it and can hopefully understand what the plan is and how it's going to work. And a lot of times you got to do a little bit of educating. As an elder law attorney, you may need to educate really, really smart people who otherwise know their stuff, but this may not be the world that they live in. So you're going to want to educate them and explain why it works and why they can do it.
What about some of the common roadblocks that guardians face? Can you walk us through some of those?
Yeah, sure. The first common roadblocks is family members. So if you have somebody who is going to oppose the Medicaid plan just because they're either suspicious of it or they think that it's not going to work out in the long run in their best interest, for whatever reason, they can object to the plan, and that could be a challenging roadblock. You could also have, as I just kind of alluded to, an education factor. People who are not involved or not familiar with Medicaid planning, some may be suspicious of it, may think this is just kind of a way for lawyers to pull one over on the government or something. And those are common roadblocks, but those could be overcome with explanation, education, and kind of showing why this is in the best interest of the individual. You as a guardian, your main focus is always what's in the best interest for my ward, my incapacitated person. You don't want to come up with a game plan just for the sake of coming up with a game plan. It has to absolutely make sense for the person that you're in charge of caring for.
What about specific Medicaid planning tools or techniques that could be effective in guardianship context?
Okay. The common ones that we see are identifying appropriate exempt transferees. And what I mean by that in English is there are certain people that you can transfer property from without causing any period of ineligibility for Medicaid. So if I just take my money and I give it to, um, you know, my brother, and he holds on to it for me, and I say, now I'm going to apply for Medicaid. That will cause a period of ineligibility if I need to go into a nursing facility. And that would kind of put me in a worse off position because now I don't have the money. I gave it to my brother, and he's not legally required to pay for my care. And I still need this care, and they're not allowing me to have Medicaid for a certain period of time. So, as an elder law attorney, we want to investigate who is in this person's life that would be considered an exempt transferee. That's usually like a spouse or a disabled child or a caregiver child. So these are all people, if they meet certain qualifications, that you could transfer resources to and not have a period of ineligibility for Medicaid, depending on the facts and circumstances. So that's usually a good tool for having a guardianship approved. I'm sorry, having a Medicaid plan approved by a guardianship court, because it would um, protect the resources, keep it within the family, and allow this person to receive government benefits without having a period of ineligibility.
So, getting back to the responsibilities and duties of a guardian, how does this impact the Medicaid planning process? Could you kind of walk us through that a little bit more? It's
Sure.
just also encompassing this whole topic. And, I think our listeners are really, would really
So,
love to hear that.
so it kind of sounds nerdy, but I really enjoyed this topic because it has an intersection of two really crucial legal services that elder law attorneys bring to the table, which is Medicaid planning or long-term care planning and guardianship. Those are two in and of themselves very complicated types of legal services that require two totally different types of skill sets. One involves courtroom drama, basically, and the other involves thinking through and kind of planning and figuring out like a puzzle. And when you put them together, it's like high stakes puzzles. But so the process typically is really dependent on a couple things. First and foremost, where are you in the process? Are you in a position where you already have a guardianship established, or do you need to establish a guardianship? Because that makes a big difference. So what we see, so just kind of give you a couple, two different variations that we see, relatively often. Something happens, person either falls and or suffers a stroke or has some sort of traumatic event where they are now in need of long-term care in a medical facility like a nursing home, and it is very likely that they are never going to be able to come back home, and they did not plan for this, and they did not have a power of attorney, they did not have a healthcare proxy. It just life happens,
Yeah.
and they'll come in, they'll say, oh my goodness, my loved one has this much money, and the cost of the nursing home is going to wipe out everything they've ever worked for. And what can you do to help us out? The first thing is, do you have a durable power of attorney? No. Okay. You have a healthcare proxy? No. Okay. Well, we need to get a guardian appointed to have the legal authority to access these resources. But in doing that, in the petition to have that approved, what I want to do is come up with a game plan to help your loved one not only get a guardian, but become financially eligible for Medicaid and immediately apply for Medicaid as soon as possible. So we will look at the application for the initial guardianship through the lens of not only what powers is this guardian going to need for the everyday occurrences or care for this person, but how are we going to immediately get them eligible for Medicaid? And I want to push the issue with the court from the beginning because I do not want any delay in the services that they're going to get. Um, if it's someone who had a guardianship already and is looking to expand the powers and now get Medicaid because they didn't think of Medicaid at any point, or the long-term care services weren't so significant where they couldn't cover the cost from the income, then you would need to apply to the court to have even more authority to have the plan done.
So, when should this happen? I mean, should it happen in your 60s, your 50s, your
Oh,
60s? Like when do you start to really think about these things? Because this, it could happen at any point.
okay. So whether you are 18 or 118, everyone should have a durable power of attorney, a healthcare proxy, a HIPAA authorization, and a living will. And I kind of um, joke, but not joke with some clients. Say, "Oh, your son or daughter is graduating from high school. They're going to college. You should get them a power of attorney and a healthcare proxy for the graduation present." And they chuckle about that. But it is a very serious thing. You never know what life is going to bring at you,
Mm.
and even if you're young or you're healthy and things are going real well, there's a twist and turn that could occur at any point. So there really isn't an age where you want to think about uh, avoiding a guardianship. So those documents, the durable power of attorney, healthcare proxy, HIPAA authorization, and a living will could by and large avoid the need for a guardianship in a number of cases. So the time is always now, especially if you're over the age of 18. Under 18, you can't really do anything.
Mm,
But for long-term care planning, I would say a good time to start thinking about that is in your 50s, mid to late 50s, or unless you've been diagnosed or have a concern for a long-term care, I'm sorry, a chronic illness that is gonna cause you to need long-term care services, then maybe it might be a little bit sooner than that. Um,
mm.
so that's the kind of thing that you want to do preventative maintenance, and you want to try to um, get your ducks in a row as soon as you can, because there is a look back period, especially for nursing home care, about 5 years. So if you transfer assets in anticipation of needing Medicaid, that could come back to haunt you if you need Medicaid within the next 5 years and can cause a period of ineligibility. So you do want to think of it in your 50s, early 60s, or when you have the writings on the wall that you're going to need long-term care services pretty soon.
Yeah.
And it's never too late, by the way. Sometimes people say, "Oh, well, I'm already, the 5-year look back period. I'm already in the middle of it. It's not going to be worth it." We can come up with a plan to at least save money. May not avoid the need for any expenditure, but it will save money.
So, in your experience, what are some of the common misconceptions or misunderstandings about Medicaid planning within guardianships that you have encountered?
Um, well, the most common that I see is that it just can't be done. Oh, we got a guardianship, so there's no shot at the court ever approving transferring assets in order to protect the money, because it's just not going to happen. It absolutely can be done. It just needs to be thought through carefully. Sometimes it's not appropriate, and if that's the case, we'll candidly speak to the guardian about that, or the petitioner who wants to have the Medicaid plan. Another common misconception is that it's really just for the benefit of the family, so that you're trying to protect the money, so that when the person passes away, it passes to the family members. That can be a part of it, but it's not the main reason. You want to preserve the resources for that person's life. We have no idea how long anybody's going to live. No one has a crystal ball here. So you want to, instead of spending down all their money to then have government benefits cover the cost of it, you'd want to protect that money, so that if the government benefits aren't available in the future, or there's other services that government benefits do not cover, you have a pool of money that you can pull from to cover the cost and make that person's life as comfortable and as um, you know, uh, easy as you can.
So, with guardianship, what role does the court play in overseeing Medicaid planning within these proceedings? And also, excuse me, how can guardians ensure that they're compliant with all legal requirements? And lastly, is there any way around get being having to go to court over this?
All right, there was like three in one. So um, I tried to jot them down. So the role of the court is going to be, initially they're going to review the application, kind of poke holes in the plan and get you to explain the plan and get you to, and then once they approve it, um, they're going to monitor you. Whenever you have a guardianship, you're always under the authority of the court. If you cannot do anything without court authorization, and you have to provide accountings annually, and the court appoints an examiner that can look into the accountings and investigates situations if they're concerned about anything. So you're always going to be beholden to the court for the duration of the guardianship. That doesn't mean they're going to give you a hard time every 2 seconds, but they are going. You have an obligation to provide a report to them to let them know, okay, this was the plan that you approved. We executed the plan, and it went according to plan, or something did not work out as we initially planned, and we need to pivot. So you're going to have to provide um, um, updates to the court after the plan is approved. So their initial role is to approve the plan, to give their seal of approval, and then to make sure that you carried it out appropriately. And then The second question was, well, how can a guardian avoid this? Was that right? So
Yeah.
then the guardian can avoid it because at that point the person's lost capacity and there's really not anything they can do without court authority. If they want to avoid Medicaid planning, um, they just don't do it and they spend down the money, which is not ideal. But in my opinion, if I'm a guardian and my job is to preserve the resources of a person, I think you have a responsibility to at least investigate the feasibility of a Medicaid plan and see what that will look like for your incapacitated person. It may not be the best option, but you got to exhaust those options to make sure that you've at least done your due diligence. And I'm sorry, Hillary, what was the third part of your one
And the
question?
and the third question, the third one part of the question was, is there any way around not having to go to court?
Oh, yes. Okay, sorry. Thank you. That was my favorite part of your question, actually. Yes, but it requires prior planning. So, as I mentioned before, whether you're 18 or 118, you got to have a durable power of attorney, healthcare proxy, living will, and a HIPAA authorization. Those documents will, by and large, avoid the need for guardianship in most cases. So, if you don't have those documents, then still meet with an elder law attorney, see if there's some sort of authority that you could rely upon. So, for instance, in very limited settings, there's a statute in New York State that will allow certain people to make medical decision in certain settings. And if those people are on your short list anyways, that's helpful. So, for instance, in New York State, my spouse would be the first person to make a medical decision for me in the event that I'm not able to make that decision. I have a great loving relationship with my wife. I'd want her to make those decisions. But if I was estranged from her for some reason, I definitely would not want, or I'm in the middle of a divorce proceeding, that's not the person I would want. So you'd want to update your documents. So uh, durable power of attorney, healthcare proxy, living will, HIPAA authorization. And if you don't have those things, you can meet with an elder law attorney. We can try to work around the need for a guardianship. But generally speaking, you're going to need one if they don't have capacity anymore. So
Well, this
it's
is
one of those things you gotta really, take care of, and people say, "Oh, I'll do it when I get around to it." No, let's do it now.
yeah, no, you're totally right, and this was so helpful. Give us just end this up with an example of a successful Medicaid planning strategy that you've implemented in your practice. Maybe you could share something with us.
Yeah, sure, there's been a number of them. Trying to think of something that would be not super duper complicated and just kinda get the point across. Okay, so I've had a situation where, a person had a guardianship, never had a guardianship, had durable power of attorney, had healthcare proxy, but they drafted the documents themselves or forms they printed out from online, and they got away with it. It was fine. It didn't give the authority to make transfers. It didn't give the authority to do any kind of loans or anything. It was just handle the banking, access financial records, and it worked. They were able to. Husband was able to get Medicaid for spouse who was in a nursing facility and had been for a number of years and transferred all the resources from the spouse to the husband. But then that husband passed away, and the money was left to the wife who was in a nursing facility. So now, after all the effort of the husband who to transfer the money out of her name and into his name to protect the money, now it's back in her name, and we're talking like $1 million. And now, 150, $160,000 a year from for nursing home care is going to eat away at that money. So we were able to do kind of an emergency long-term care plan to preserve not all of it, but some of it, or a good portion. I would say like 40, 50% of it. And we had to apply through the court to show, hey, listen, there was a pattern of Medicaid planning. She's wanted to do this. She's done it in the past. It was just, but for kind of misguided or misunderstood, actions on behalf of the now deceased spouse that we're kind of back in this position. And this is the recommended plan we have. These are the people that she has in her life that would otherwise receive this had she passed away, and they're involved in the process. So, in that kind of example, you have someone who is would rationally do this had they had the authority, and
Mhm.
took steps, in fact, to do some Medicaid planning, but it just fell short. And if they had just kind of met with a qualified elder law attorney in the beginning, we probably could have avoided this and never been in court for a guardianship, quite honestly. So it happens, and we're here if it does happen. That's kind of the key here, is that if you have a situation where you need a guardian or you need Medicare in some way, shape, or form, you really should speak with a qualified professional. And a lot of times people say, "Oh, well, it's going to be too expensive." It's more expensive not to, quite honestly.
Yeah, definitely. Well, Eric, on that note, can you tell our listeners how to get in touch with you to learn more about this and the Russo Law Group?
Absolutely. You can always visit our website at vjrussolaw.com. You can send emails to have you can call our office or my Garden City office where I'm located. We have 3 convenient locations. We have Garden City, New York, Ilandia, New York, and Lido Beach, New York. We also do home visits and virtual meetings. And telephone number is 516-683-1717. And we're happy to speak with anybody and try to help them as best we can.
Thank you. Thank you so much for being on the show.
You're welcome. Thank you so much, Hillary.
This show was produced by Hillary Topper and sponsored by the Russo Law Group, Long Island's signature elder law, estate planning, and special needs law firm. For more information, visit vjrussolaw.com. Also, Vimazi, the shoes I love to train in. Go to Vimazi, VIMAZI.com, and check out my website at atriathletesdiary.com for a special discount code of 25% off of all Vimazi products. Also, Metadyne. It's an incredible company for all your injury prevention and pain relief products. I have a discount code of 20% off of them as well. You can go to metadyne.com for more information, or again, you can go to my website at atriathletesdiary.com/discounts to get a discount for any and all Metadyne products. And PlayTry, your multi-sport specialist for all your triathlon needs. They have so many opportunities, including franchising. If you love the sport of triathlon, check out playtry.com and learn more about opportunities, or if you want to shop there, check them out. They've got great prices and they've got amazing customer service.